Okay. So I'm just going to rattle off some cases off the top of my head right now that are important for this lawsuit. Are important for camping lawsuits in general. All right. So when I learned how to edit, this stream will be much shorter. Um, all right. All right. So for my lawsuit in particular, any of the major due process cases, which there are many, which I won't name. The argument for due process is that certain fundamental rights have been violated by this law, and so strict scrutiny should be applied. And this involves the requirement that the city have a compelling reason for manifesting this law, and that the mode of manifestation in writ be narrowly tailored and done with least restrictively of these rights. So the fundamental right is bodily integrity mainly. That'd be sleeping. The First Amendment rights have been noted to have been violated, etc. So there's due process involvement. So the burden of a compelling government interest must be, coughed up by the city. That is an impossible task, basically, because the published intent of this law is, it may not be easy to get now, but I have it somewhere on the cloud. The city has hidden these documents, made it more difficult to get once I started defending myself. One of the legislative intents is from an interdepartmental memo, and that's to make it legal to be in RVs again, because the previous law made it illegal to occupy an RV for any reason whatsoever. And I surmise that that's why 17182, which is private property camping, is now has branched into two sections, A and B, and that the language for B defines camping to be occupying a motor vehicle for the purposes of living or sleeping. That makes it legal to occupy a motor vehicle as long as you're not camping, right? So it restored the legality of occupying a motor vehicle to the city. So people can be in their RVs now. All right, which met that interdepartmental memo condition. All right, so the major cases for, cruel and unusual punishment are Robinson v. California 1962, which, by the way, incorporated the Eighth Amendment's cruel and unusual punishment clause unto the states. Previous cases had already presumed that this condition had been incorporated unto the states. It's a federal condition that's incorporated unto the states. I haven't checked every state to see if no state is bereft of this clause. In and of itself, I believe that every state in the union has its own cruel and unusual punishment clause. Nevertheless, the meaning of the clauses within the states isn't necessarily the same as the meaning of the clause, the federal clause, because, you have case law and different possibilities of interpreting it. I suspect that originally they were the same, but there's been some divergence. For example, here in Colorado, the Constitution was ratified in 1878 or something like that? I don't know. So there's been about 140 years of possible divergence. And there has been some divergence because this Supreme Court of the state of Colorado has made some strange rulings, which seems to decouple the cruel and unusual. The federal law is that it must both be cruel and unusual simultaneously in order for it to meet this Eighth Amendment condition. But there is a case law from Colorado where one or the other suffices. Okay, so Robinson incorporated the federal condition unto the state. So now all of the states are bound to not impose cruel and unusual punishment upon its citizenry, in the sense as interpreted by Scottus. So that case is important, mainly because of the predisposition for and the momentum that the cruel and unusual punishment arguments have gathered over the years. There are lots of other possible arguments, but there's been 12 or 13 major cases where cruel or unusual punishment has been used, has been won several times. Jones v. California. There's Pottinger in Miami. However, both of those were civil suits, and one of them was settled. And there's other cases where the judiciary of various states has ridiculously said that homelessness is not a status. Okay, so Robinson versus California. Okay, homelessness. Robinson versus California. There's the only so far it's the only case in the history of Scottus where the condition imposed by another case, which is important, which is Ingram v. Wright, 1977, which held that cruel and unusual punishment imposes substantive limits on what can be made criminal and punished as such, was held to be a condition that the Eighth Amendment cruel or unusual punishment clause must satisfy. That the legislature cannot nilly-willy write whatever laws it wants to. It has to write laws which have limits. There are limitations on what laws it can make. And the law that was made in California was, it shall be illegal to be addicted to the use of narcotics. That was held to constitute cruel and unusual punishment in 1962, because it targeted a status or condition that the person was simply unable to remove himself from, had no control over, whether or not the law was violated by him. Even if he had, the person may not have ever done narcotics. In particular, the narcotic of choice here was heroin. Within the state, he might have done it elsewhere, or he might have been addicted and not done it in the state, and yet still be an addict. Once an addict, it's difficult to remove oneself, and one cannot instantaneously remove oneself from that status. It takes time. So although this wasn't brought up by the Supreme Court, it could have been. The law itself doesn't give fair notice in that there ought to be a period of time by which one can remove oneself from this status in order to, give adequate notice of heads up that, hey, it's illegal to be in this status. And there wasn't given any time period. It was just strictly illegal to be addicted to the use of narcotics. So that's the case Robinson, 1962, Robinson v. California. There's also Powell versus Texas, which is 1968 or 9. And that was just an alcoholic, chronic alcoholic, who may or may not be homeless. And history may have changed if the court had any record one way or the other. But the court had no record of whether or not this person was homeless, so there was no evidence whatsoever. Evidence was given that the person had a wife and kids, and presumably they were housed. But the law in question here was the Texas law. It's illegal to be intoxicated in public. And only eight Supreme Court justices ruled. One sat out, and it was a 4-1-4 decision, so it was a tie. The prevailing decision is that that's not cruel and unusual punishment. And there were many opinions given. In both Robinson and Powell, there weren't just two, like a group of dissenters and a group of agreeers. There were bifurcated decisions for different ways of that justices thought about it. And one justice, I think it was White, said that if there were any evidence whatsoever that Powell were homeless, that he would have voted that this is cruel and unusual punishment, because Powell would have had no place to drink then, and he had the irresistible compulsion to drink, as the person said. So that could have changed history. Okay, so we have Robinson, we have Powell. Ingram Wright, 1977, establishes a three-tier, basically three ways that cruel and unusual punishment can be violated. One is by the kinds of punishments imposed upon prisoners. So that could be like public floggings or stoning, or I don't know, all sorts of archaic ways. When cruel and unusual punishment was first established in the English Bill of Rights in 1869, it didn't preclude what would be considered to be barbaric methods of punishment today. So the Supreme Court concluded that it just has to do with the evolving standards of decency. So whatever is abhorrent to the general public in terms of the evolving standards of decency is considered to be not okay forms of punishment. You can't, like in the Philippines around, I think it was 1909. Oh, is that the case? Weems? I don't know. Anyway, some dude was forced to sit out in the sun for 7 hours handcuffed to a pole. That was considered to be cruel and unusual punishment by means, mode, type, kind, way, etc. So that's one way that cruel and unusual punishment can be imposed, is by the kind of method, or the method of punishment. So another has to do with proportionality. How much time, and generally when you think about proportionality, you think about time when it comes to punishment. And this is a topic of great debate amongst and between different Scottices of different eras. So, for example, Justice Thomas says there is no proportionality within cruel and unusual punishment, the Eighth Amendment. And he doesn't mean that there's no proportionality within the law. He just means that it doesn't emanate from the Eighth Amendment. He thinks that it emanates from some other places, I can't even remember how was that. Anyway, and then Scalia thinks it applies only to the death penalty. Other justices have concurred that one can't differentiate between a 10-year and a 20-year sentence, for example, for a felony crime. It's been applied many times to 3 strikes, because there's been at least 2 or 3 main cases with 3 strikes where people have gotten life in prison for very, very minor nonviolent crimes, which one of them was $180 total, I think. Another one had to do with stealing videotapes from some kind of video company, and with the idea of reselling them. And he did 2 of them within 2 weeks. I think he stole them from Walmart. And individually, it wouldn't have constituted a 3-strike violation because each one was less than $100 and would have been petty. But together, it put him in life, in behind bars for life. So, okay, now let's get to the third tier. So the first tier is the mode or kind or type of punishment, like how much pain you're going to, torture's cruel and unusual punishment. You can't torture somebody. The second one has to do with proportionality. Proportionality exists, but how much of it emanates from the Eighth Amendment is unclear. Scottus is totally... It's kind of a hot debate topic. So it occurs for the death penalty, for other forms of punishment. It's unclear and must be argued on a case-by-case basis as to whether or not it would apply and how much so. And the third tier is the one which is used in camping violation laws for homeless people. And that's Ingram Wright said that cruel and unusual punishment, quote unquote, imposes substantive limits on what can be made criminal and punished as such. So let me rephrase that. It imposes substantive limits on what can be made criminal and punished as such. So the two are coupled, the made and the punishment. So it has no. If you're going to make a law which has no fines or punishments whatsoever, any fine is a punishment. It's been ruled. You don't have to go to jail. Fine is a punishment independent of the excessive fines clause, right? So yeah. So a fine is a punishment. Anyway, yeah. So there we go. So that's Ingram Wright, 1972. Now, in Martin Boise, there's some judges who, when they petitioned for rehearing en banc, claimed that this tier doesn't really exist, or they tried to ignore it. There was some terrible butchery done by some of those judges who could write well, but certainly couldn't argue their way out of a hat. It was terrible and really belligerent arguing against the homeless. So now I guess I'm going to have to look something up because there's a corollary to that, in Robinson. And this is, So I should look that up probably in Justia as a complete case. And, because I really like it's a precursor to the beautiful phraseology used in Ingram versus Wright. It's kind of a sloppier version of it, but this is 1962 as opposed to, I think it's in footnote 14 as opposed to 1977. So let's look up footnote 14 here, footnote 2, because I haven't memorized this or whatever. I don't remember it. Justice White dissenting. Okay. Oh my God. I don't see footnote 14. Do I have an entire case as opposed to the syllabus? Yeah, I guess I do. Okay, so um, I'm looking at the opinion. Just wait. I think need to look at the main opinion. Okay, let's see. Blah blah blah. This is Robinson. Okay, this is. As long as I'm here, I might as well hit some highlights. Because there are other things from Robinson, like for example, there's in Robinson is referred to in another case that's important for proportionality that I think is called Marino, where Scalia referred to something that's in Robinson, and the thing that's in Robinson is that imposing even 1 day in jail for the crime of the common cold would be cruel and unusual punishment. And the question is whether or not that would be a third tier or a second tier Ingram Wright imposition, meaning whether or not it would be proportionality or whether or not it just this kind of law couldn't have been made. And Scalia said it wasn't at all obvious that it was proportionality. It could have been the other way. It could have just been that. So now my hope is that I'll learn how to edit and we'll re-edit this and probably redo all these tapes because right now I'm just winging it. Oh, look, even 1 day in prison would be cruel and unusual punishment for the crime, quote unquote, of having a common cold. To be sure, imprisonment for 90 days is not in the abstract a punishment, which is either cruel or unusual, but the question cannot be considered in the abstract. Even 1 day in prison would be cruel and unusual punishment for the crime of having a common cold. Okay, that's page 667. No, it's page 369, US 668. Sorry. Footnote 4. I need footnote 14. Come on. Footnote 9. Come on. Maybe I'm misremembering footnote 14. Oh, brother. There's a lot. There's got to be like 30 pages here. Where the hell is footnote 14? Maybe I should remember the page number. Most of the page numbers are 666 or 667. In Ingram Wright, it's 666. And 666 in Robinson also has something important. So let me see. This is page 675. Let's go to page 66. I just remember that I wrote a bunch of briefs. None of them were argued. The city just rolled over. Here's 668. All right, let's see. What do we have? Ah, 668. Okay, that's okay. Getting closer. Here's 67. Okay. Here we go. 666. Okay, that's not important. Oh, but this is interesting. Let me read it. This statute, therefore, is not one which punishes a person for the use of narcotics, for their purchase, sale, or possession, or for antisocial or disorderly behavior resulting from their administration. It is not a law which even purports to provide or require medical treatment. Rather, we deal with a statute which makes the status of narcotics addiction a criminal offense for which the offender may be prosecuted at any time before he reforms. California has said that a person can be continuously guilty of this offense, whether or not he's ever used or possessed any narcotics within the state, and whether or not he has been guilty of any antisocial behavior there. California backed this up. If they hadn't done this case never would have made the Supreme Court. It is unlikely that any state in this moment in history would attempt to make it a criminal offense for a person to be mentally ill or a leper or to be afflicted with a venereal disease. A state might determine that the general health and welfare require that the victim of these and other human afflictions be dealt with by compulsory treatment involving quarantine, confinement, or sequestration. But in the light of contemporary human knowledge, a law which makes it a criminal offense of such a disease would doubtlessly be universally thought to be inflicting cruel and unusual punishment in violation of the Eighth Amendment. See Francis versus Reese Weber. I looked at law, but that was a long time ago. In that case, I don't remember what the hell it says. Okay. Something. The state recognizes narcotics addiction as an illness. Indeed, it is apparently an illness we contracted innocently or involuntarily. You could be born with it. We hold that a state law which imprisons a person thus afflicts criminal, even though he's never touched any narcotic drug within the state or been guilty of any irregular behavior there, inflicts a cruel and unusual punishment in violation of the 14th Amendment. Now, this is where they incorporate the. By the way, how does it violate the 14th Amendment? Well, the due process clause of the 14th Amendment is being used here. This is actually, I think, the only freaking line in this whole case which incorporates the 8th Amendment onto the states through the 14th Amendment. All incorporation is done through the 14th Amendment's due process clause. Although the privileges and immunities clause is a dual source of incorporation, which might have been used for other bills of rights clauses, but privileges and immunities has sort of been messed up by the slaughterhouse cases. And it's unclear whether privileges and immunities had any sort of limiting. The Supreme Court has not interpreted any limiting apparatus to be applicable to it. So that's sort of like rights which are super powerful, like First Amendment rights. more powerful than fundamental human rights, which are due process rights. But the question cannot be considered in the abstract, even one day. Okay, so that's even 1 day in prison would be cruel and unusual punishment for the crime of having the common cold. Okay, that's not footnote. That's not what I freaking wanted. 668. Okay, I need footnote 14. Come on, footnote 14. Where the hell are you? Blah, blah, blah. Ooh, they reference something from the year 1713? What was that? No, it's not. Huh. Come on, footnotes. Ibid. Ibid is not a valid Scrabble word. Ibidem is. At least when I played tournaments a few years ago, like 10 years ago. Come on. See, this is ridiculous. This is like pretty important though as a bookend to Ingram Wright, because some justices just pretend that it doesn't exist, the third tier. They pretend the third tier doesn't have to do with the kinds of punishment. I mean, it mentions a punishment, but all cruel and unusual, all Eighth Amendment cruel and unusual punishment deals with punishment imposed by the state, post-convictive punishment. And all the cases mention that. The third tier, the kind of punishment is kind of hidden within. It imposes restrictions upon the legislation. So the first two tiers are kinds and, duration of punishment, like proportionality and, cruelty. I'm still looking for footnote number 18. I don't know why I can't find it, because it's probably yeah. Justice White dissenting. Now, when it comes to brains, I view Justice White at the time that this analysis was performed, 1962 to 1968, to be the sharpest of the Scottish participants. Later on, his brain seemingly deteriorated and he had difficulty communicating. I don't know what illness he caught or whatever, but during this period of time, he was sharp as a tack and very, very sharp guy. And blah, blah, blah. Although nobody analyzed it the way I did, which is actually a very simple mode of analysis, which comes from my physics background and mathematics background, which is that there's no difference between an act and a state of being. A status is a socially recognized state of being. It's all that it is. A state of being is a state of being, okay? states in math and physics are, and in computer science are very important. State analysis. So, and everywhere in engineering, state analysis is important too. So the thing is that just an act is just a change of state of being, right? You evolve from the state of B having not done the act to the state of B having done the act, any act. Now, a law and any change of state of being involves it. All right, so I mentioned this somewhere, but okay, so there's a duality between acts and changes of states of being, and there is no any law which can be written as prescribing a state of being can be written as prescribing an act, and vice versa. Although one has to do with the differential of the other, right? I described that earlier. I'll do that again somewhere. I'm looking for footnote number 16. Oh, man. Footnote 14. Oh, it's not there. Oh, I'm sorry. All right. Well, was that in Powell? Powell. It might be in Powell. Footnote 16, 14. Excuse me. All right. Yeah, it is Powell. Okay, so we're talking about a few years later. We're talking about 6 years later. But I want to have this as a bookend to Ingram Wright. And I want to have a precursor to this, but I can't find any precursor to this. This is a precursor to Ingram Wright. God, these cases are both huge. With like 30 to 40 pages or 50. Footnote 6. Footnote 14. Okay. See, there are footnotes. To decisions. No, there's another one. The court did not hold in Lambert v. California, 355 U.S. 255, 1957, the person cannot be punished for a crime of omission if that person did not know and the state had taken no reasonable steps to inform him of his duty to act and of the criminal penalty or failure to do so. It is not suggested either that Lambert established a constitutional doctrine of mens rea. See Generally Packer, mens rea in the Supreme Court, 1962 Supreme Court Review 107, or that the appellant in this case was not fully aware of the prohibited nature of his conduct and the consequences of taking his first drink. Okay, that's not what I'm looking for, but I thought that was funny. Oh, it was Justice Black too, right? It was Justice White and Justice Black. Okay, I'm looking for freaking footnote number 14. Forget footnotes. I should go by page numbers from now on because that's just ridiculous. Excuse me. All right. Here we go. Okay, it must be footnote 14 of Justice White's. After Justice White's opinion. So we had an opinion of Justice Black and then an opinion of Justice White. I haven't really noticed that before. Come on, footnotes. Ah! There it is. Okay. It's on, page 392 US 566. So it's not 666, it's 566. And here it goes. Okay. This is really important. It's the bookend to Ingram Wright. It is settled that the federal Constitution places some substantive limitation upon the power of state legislatures to define crimes for which the imposition of a punishment is ordered. It goes on to say, in Robinson v. California, the court ordered a conviction under California state statute making a criminal offense for a person to be addicted to the use of narcotics. At Robinson's trial, it was developed that the defendant had been a user of narcotics. The trial court instructed the jury that to be addicted to the use of narcotics is said to be a status or condition and not an act. However, any law, any verbiage, never mind. It is a continuing offense. Okay, now that's an interesting thing. If you analyze from first principles any law, which is embedded in writ and communicated information theoretically from mind to mind, through words, it can be, what was I going to say? I'm multitasking within my mind. Let me just read this. To be addicted to the use of narcotics would be a status or condition and not an act. It is a continuing offense. Okay. Anyway, if you analyze from first principles, the violation of any law occurs at a time t. There's whereby before time t, no violation of that law can said to have occurred, and after time t, the law violation can be said to have occurred. So now the problem is that there are two kinds of law violations. There are types of which the violation occurs and is immediately extinguished, which is happens at a point of time t. And there is another kind in which the law is in continuous violation for an interval of time. So that would be, it occurred every time between t and t plus delta t. And those are the only two kinds of law violations which occur. And the convention has it that laws such as trespassing, for example, if you trespass once in somebody's yard, the convention is to apply a single violation to that, right? Can we say that? Well, yeah, that's generally the case, but not always so. There's a Supreme Court case in which somebody trespassed for an hour and 45 minutes. The maximum penalty was 30 days, and the person was given a 5-year sentence. This was around 1920. Why? Because they gave him a bunch of violations. They said that, every 3 minutes or something, he violated constituted an individual offense. When in actuality, a law like jaywalking, where if you're in the middle of the road and the light turns red and you cross, over, does that constitute one violation or does it constitute an infinite number of violations? So, for example, the city of Fort Collins could catch Bill Gates jaywalking and give him, 100,000 tickets, and each ticket might cost $100, so gain $10 million from Bill Gates. But why be so? Why not be a little bit more greedy? I mean, Bill Gates could easily afford $10 billion, right? So why not give him, 10 million violations? 100 million violations of jaywalking, and for the 10 feet that he was walking through the intersection while the light was red, rather than just one. Well, it's just by convention. So, and here we go. The state, it is settled that the federal Constitution places some substantive limitation upon the power of state legislatures to define crimes for which the imposition of punishment is ordered. In Robinson versus California, the court considered a conviction under a California statute making it a criminal offense for a person to be addicted to the use of narcotics. At Robinson's trial, it was developed that the defendant had been the user of narcotics. The trial court instructed the jury that to be addicted to the use of narcotics is said to be a status or condition and not an act. It is a continuing offense and differs from most other offenses in the fact that it is chronic rather than acute. And that sort of like happens at a point rather than an interval, and it continues after it is complete and subjects the offender to arrest at any time before he performs. So that's true of any non-interval law. It just like jaywalking, trespassing, speeding. If you're speeding, the speed limit's 70 and you're going 75. Well, the cop can write you an infinite number of tickets because when you slow down from 75 to 74.99999 to 74.9998, each of these can be said to be an individual offense. So it's just a convention that we don't do that. It would be unfair. And there's nothing special about Robinson in terms of this acute, chronic rather than acute. It continues after it is complete. There's nothing at all special about Robinson. About it is illegal to be addicted to the use of narcotics. However, this objection was noted by me and by the court as being a problem because the convention apparently hadn't been established. Well, the convention of just immediately ticketing somebody for something that they had no control over, removing themselves from without giving the person fair notice, what happened and was unfair. Okay, so that was the main thing that I was after there. So it's page 544 of Powell. All right, so the important cases that I've mentioned so far are Robinson v. California, Powell versus Texas, Ingram versus Wright. Now, that's for cruel and unusual punishment. For due process, there's a ton of them. Due process is extremely common. And, just look up the most recent Scottish case, I suppose. But the mechanism, the machinery is very well established. It's similar to the equal protection mechanism. And actually, it sort of blends into equal protection. There's different levels of scrutiny. There's strict review, and there's like intermediate review, and there's the lowest level review. Which is the rational review standard. But what we have is a compelling. We have strict review because of the violation of fundamental human rights. So that I'm going to throw off to the side. That's encapsulated and sort of easily accessed later. This has to do with with the cruel and unusual punishment. And I have my own arguments, which is different than any argument that's ever been presented that I know of. And it's pretty simple. And I'll do a separate tape on that. Okay, so then we have the facial challenges as opposed to applied. The civil suit, of course, the standard of view is not beyond any reasonable doubt. It is preponderance of the evidence. So it's an easier standard to meet, yet I want to be able to meet any standard of view. And the most strict that I can think of is Salerno. So let's look up Salerno to get the exact word verbiage. It has to do with the set of all possible, not all. First of all, legislative act. Okay, let's look up Salerno. Oh, do I have to wade through? This is 1987. Sounds about right. He's a mobster. Yeah, the Bail Reform Act of 1984. Okay, so now let's see if I can find the salient verbiage here. It only looked at part of the Bail Reform Act. So it excised and severed it. It's not in the syllabus. It must be in the case. Blah, blah. I don't like this ruling because it's kind of vague. And it seems excessive, but nevertheless, here it is, and we can meet it because Fort Collins City Ordinance 181 is so ridiculously, outrageously unconstitutional and targets on face only rights, not acts. Well, it targets rights through acts, like freaking right to sleep. See, I don't have this page number memorized. I don't have the verbiage memorized. Because it uses the word act 3 times. And the word act is capitalized as opposed to in small letters, which could mean that it's a Congress, an act of Congress, like the Bail Reform Act. But it has been interpreted by the state of Colorado to apply to small letter act as well, which means to any freaking piece of legislation. Although the way the state of Colorado did this is tricky because at first it had to do with the freaking state of Colorado's constitution, which can be argued to be an act, like a capital letter act. As opposed to any little piece of legislation written by any city, which is an ordinance. So yeah, I'm assuming I'm going to learn how to freaking edit and get rid of this. Let's see. I just want to find the salient verbiage that's used over and over again afterwards. What was that? That was interesting. Authorization or pretrial detention on the ground. Oh, they're quoting. So this is probably from the mobster's lawyer. Oh, yeah, that never mind. It's not that interesting. All right. Oh, here we go. This is 1987. So this is before Fallon did his analysis in around 2010. Professor Fallon is a Harvard law professor who is a world-renowned expert on facial challenges and who analyzed Supreme Court facial challenges and found them to be bereft of the gravity given to them by the verbiage of the Supreme Court in describing facial challenges itself, and of the frequency of that the court says that they are brought up in front of the court. In particular, Fallon found that they're not rare, that they're actually the most common form of challenge as opposed to as applied. But here, let me read. This is what the prevailing opinion said. I forget, is that what Justice, never mind, said in the United States versus Salerno 1978. A facial challenge to a legislative act, capital act. All these are small letters. A is capitalized. Facial challenge to a legislative act, capital ACT, is of course, the most difficult challenge to mount successfully. That's actually debated by Fallon, because the probability of winning a facial challenge is also higher than the probability of winning an as applied challenge in terms of thrown lots in Scotus during the period of time that he studied, which is a modern period of time. Since the challenger must establish that no set of, okay, here we go. The challenger must establish that no set of circumstances exists under which the act, capital ACT, would be valid. Okay, now what the fuck does this mean? Okay, first of all, why does he capitalize act? I think he's talking about legislative, like acts of Congress here, okay? He's not talking about state legislative acts. He's talking about, at this point in time, where Scottus is ruling here, he's talking about acts of Congress. And later it gets interpreted to be any freaking city writing any freaking law. But, okay. And the challenger must establish, now this is up my alley. This is written in terms that sound very mathematical. Since the challenger must establish that no set of circumstances exists under which the act would be valid. Now that sounds almost mathematical. Now, if I were to rephrase it, it could be mathematical. Let me rephrase it in my own verbiage and show you how that would go. Since the challenger must establish that no possible set of circumstances could exist or exists under which the acts would be valid. So that's mathematical. But this isn't phrased that way. It's phrased that since the challenger must establish that no set of circumstances exists under which the act would be valid. So what does that mean? It means extant set of circumstances. This is my interpretation. Not that no possible set of circumstances exists, but no extant set of circumstances exists under which the act would be valid. However, the only way to get around this with Fort Collins City Ordinance 181 is to show that no possible set of circumstances exists because we don't have access to all extant set of circumstances. In other words, all as applied cases at this moment. We're not talking about previously as applied cases or future as applied cases. Okay, but this is really important, this verbiage. The fact that the bill, it's really funny because this could also be interpreted as more sweeping because an act, when they use the word capital act, A-C-T, they're talking about like a self-contained piece of legislature done by Congress. It's almost like a freaking book. Like, not any chapter of the book or any paragraph of the book or any subsection of the book or whatever. And yet, when they analyze Salerno here, what they're doing is they've severed a piece of the act, and they're analyzing a piece of the act as if it were the entire act. And if one interpreted this strictly, one could say that make any unconstitutional law constitutional simply by appending any constitutional law to it. For example, I think we can all agree that jaywalking laws are constitutional. So take any unconstitutional law L and append jaywalking to it, and then you would have a constitutional law according to this interpretation, a very strict interpretation, because there would be valid applications because of jaywalking, the jaywalking applications. So, okay. The fact that the Bail Reform Act might operate unconstitutionally under some conceivable set of circumstances. Now, here we're talking about theoretical. Some conceivable set of circumstances is insufficient to render it wholly invalid, since we have not recognized an overbreadth doctrine outside the limited context of the First Amendment. The Supreme Court hasn't, but other courts have. And that's an interesting application of overbreadth. And that's an interesting observation, because that would be kind of a weird application of overbreadth. We think respondents have failed to shoulder the heavy burden to demonstrate that the act is facially unconstitutional. Fallon thinks that the burden isn't so heavy. All of this verbiage, Supreme Court Scottish verbiage from the last part of the last century has now changed because the Supreme Court, through Fallon, now recognizes that what they're saying is just simply not true. Their characterization of facial attacks as opposed to as applied attacks. Okay, so that's not the main piece of verbiage that I'm looking here. Oh, Palco, that's interesting. The main verbiage I'm looking for is embedded within 50 fucking pages here somewhere, probably. All right. Why don't they use ibidem instead of ibid? All right. So. Well, anyway, that was a kind of a slightly important piece of verbiage. Because that's not the main thing. Oh, brother. Oh, my gosh. I must have missed it up here. This is Rehnquist. So there's also Elrod Burns. I mean, there's also people in the interest of James versus Colorado. And all that does is establish that the right to intrastate travel, not interstate travel, intrastate travel in the state of Colorado is a fundamental right. I'm looking for the relevant, the important, and oft quoted and repeatedly quoted and interpreted verbiage here from Scottus. And I think that was just it. I just, yeah, that's right. This is it. Okay. A facial challenge to a legislative act, capitalized, is, of course, the most difficult challenge to mount successfully. Proven, this, by the way, is proven to be untrue by Professor Fallon. Since the challenger must establish, okay, and here goes, here is the punchline, that no set of circumstances exist under which the act, capitalized, would be valid. Not that no possible set of circumstances exists. However, if you prove that no possible set of circumstances exists, under which the act would be valid, you'd be also proving that no set of circumstances exists would be valid. And if in my case, if I sue, and the city, if the judge wants to do a Salerno as opposed to a due process, and include an overbreadth, I think I'll probably include every possible form of facial challenge argumentation. Anyway, but a Salerno is like the meanest one that you could do to a plaintiff, the meanest one that the judge could sick on me. It should be fairly trivial to satisfy by just simply extending it to be showing that there's no set of possible situations under which the circumstances under which the law would be valid. And the way to do that is to look at just every single clause, and there's only 4. The 5th one adds nothing. And to do it one at a time, right? That any possible circumstance under which this law would be violated must trigger at least one of these sufficient conditions. And if you look at the union of the set of all possible sufficient conditions, then you're covering all possible circumstances for which the law would be applied. And if you just target them one at a time and show that none of them suffice, you're done. And that should be hard. So to sleep, to spend the night, to reside or dwell temporarily, or to perform activities of daily living, such as eating or sleeping. Now, to sleep. Okay, I'm arguing that sleep is a fundamental right. And I'm not doing it the way that California did. What was that? It was that, I keep thinking turf state or stuck state or whatever. Anyway, there's a Hawaii case where a homeless person represented themselves, and the frickin' Supreme Court of Hawaii made a ridiculous ruling. The homeless person argued it incorrectly, or he chose extremely suboptimal argument, which led the state of Hawaii just to make some kind of ruling which is almost irrelevant, which says that it is not a fundamental human right. Sleep in a public place is not a fundamental human right. And that's just like saying that the right to travel through, across a red light in a crosswalk is not a fundamental human right, or the right to bear arms at a Trump rally is not a fundamental human right, or I don't know, the right to yell fire in a movie theater is, when there's no fire, is not a fundamental human right. It's a conditional right. So it has no bearing or relevance, or it has nothing to say about whether sleep itself is a fundamental human right. And sleep itself is encompassed by bodily integrity, and therefore they have it ass backwards. The city of California, the state of Hawaii, the city of California, the state of Hawaii. What case was that? It's really an interesting case. Sturch, Sturch. It's Sturch State. Now, I would not recommend including that in any arguments because we don't want any judges to see this, right? Judges might find it on their own, but they would be applying it invalidly because the logic is ass backwards. It's a total illogical application. All right. So, anyway, so yeah, I think I can satisfy Salerno just through a sort of mathematical application of this. Be a mathematical logical. I mean, to me, logic and mathematics are the same thing. Like, logic is a subset of mathematics, really. Oh, there's all sorts of mathematical logics. Anyway, but so sleep's a fundamental human right. Spending the night, we already said that violates all sorts of First Amendment rights. It also violates the Eighth Amendment cruel and unusual punishment clause because it makes it illegal to be addicted to the use of narcotics in Fort Collins for a small part of each night, right? All right, so to reside or dwell temporarily with or without bedding or other camping gear, with or without shelter, that's totally ambiguous. No idea what that means. So I'm reside or dwell means to linger. Dwell means to linger. Reside actually adds nothing to dwell. So to linger is to loiter, really. And we have the right to loiter, right? I mean, the constitutionality of loitering law, the unconstitutionality of the anti-loitering laws is very well established through all sorts of case law. A condition must be attached. The only constitutional loitering laws are loitering laws, which is it's illegal to loiter. To spot loitering laws, like the city of Fort Collins has a law which makes it illegal to loiter. Well, it makes it illegal to not follow signs, and then they have no loitering signs placed at parts of the city that this deemed important, and that's spot loitering. So you can't the entire city. You can't write a city-wide non-loitering law. And most cities do not have them. There's one in Florida, which is close to being violative, but I think that was reviewed. That one seems close to me. Anyway, so if reside or dwell temporarily, meaning to linger, or to loiter, that interpretation certainly can't hold. So I guess I just leave it up to the city to come up with an interpretation of what the hell that means. It can't mean to spend the night because the spend the night is already covered. So they're going to have to come up with an interpretation. And then I'm going to argue, or it can be argued then by my lawyer that whatever their interpretation is, they should have written in a law, and that, well, if we're going to sever this, as Salerno was severed itself, that maybe this law can be reduced to whatever their interpretation is. Now, activities of daily living. Well, activities of daily living are protected OSHA rights. So you can actually argue that really this is violative of, I think it's 18 U.S. 241 and 18 U.S. 242, deprivation of rights under color of law, because these are federally protected OSHA rights. Now, OSHA has to do with occupation, and it has to do with long-term healthcare facilities, where all patients have their rights to perform activities of daily living guarded. So the city ought not to be able to violate our right to perform activities of daily living, as it does through 17181 and 17182A to everybody within the city, because 17182 has no home interior exclusionary clause. It's 17182 is not only applicable to the curtilage, but also to the home interior, etc. All right, as a textualist interpretation of this law would have it. Textualist interpretation of the law is the only one to actually make sense into it, because otherwise the number of impossible interpretations is so broad as to preclude fair notice to anyone, the police, the judiciary, to the person who is ticketed. All right. So activities of daily living, it's a common health care term. It's also a legal term in all the 50 states have it. And what activity, and by the way, the city couldn't have come up with it accidentally. The average vocabulary of a 8-year-old is 10,000 words. Activities of daily living is 4 words. If the average 8-year-old were to draw all of the words in the vocabulary one at a time, with replacement out of a bowl. With replacement is the right way to look at this, because you can have 2 words that are the same in any phrase and have it be meaningful. Then the probability of them drawing the phrase activities of daily living out of a bowl at random is 10 to the negative 16. Their vocabulary is 10,000 words. 1 out of 10,000 is 10 to the negative 4. These are independent drawings or events. There's 4 of them. 10 to the negative 4 times 10 to the negative 4 times 10 to the negative 4 times 10 to the negative 4. Right? 4 times 4 is 16. So 10 to the negative 16. So that is so minuscule as the, 1 millionth of 1 millionth, right? So it can't be said that the city did this by accident, especially since it's a common healthcare and legal term. Therefore, it can only be noted that they came up with it on purpose. So it's an intentional use of a common legal and healthcare term. Now, these legal and healthcare terms are taught in school, and an acronym for it is DEATH, DEATH, to help healthcare students learn what activities of daily living are. And what activities of daily living are is D stands for dressing, E stands for eating, A stands for ambulating, T stands for toileting, and H stands for hygiene. DEATH. So we have dressing, eating, ambulating, toileting, and hygiene. Now let's take a look at this freaking thing that the city wrote. We severed it, we separated it. So this would be the 4th clause. To perform activities of daily living, such as eating or sleeping. Well, eating is included in DEATH, but sleeping is not. So the city must have some wider range of activities of daily living in mind that supersedes and it includes and deaths, right? It's just a much broader range of activities that they must have in mind. Well, I mean, first of all, there are certain things in death that we can eliminate immediately that the city can't have us do. And immediately that would, I think that we should just use the general interpretation. The city didn't specify any more. So ambulating is immediately out. That's against the right to interstate travel, the free assembly, First Amendment right to free assembly, etc. Toileting, right? I mean, bodily integrity. If you don't toilet, you're going to die eventually. So bodily integrity, you're going to explode. Ambulating, dressing. I think dressing is a fundamental human right, but I'm not going to touch it. You're going to die unless you live near the tropics if you want to live in a nudist colony year round. Hygiene is bodily integrity. It may take years for you to die, but you could just fall apart. Anyway, emulating itself is fission. All we need is one. So what we have is the only possible point of contention under a Salerno analysis is residing or dwelling temporarily. You can't make it illegal to sleep everywhere at all times. You can't make. That's what it does. Incidental napping, irregardless, incidental napping means nothing. Incidental napping is napping without mens rea. Incidental napping is falling asleep because you're exhausted, which could be dangerous. You could fall asleep in the snow and freeze to death, as opposed to like sheltering yourself when you fall into the snow and camping and be illegally camping. Anyway, so those are the important laws, and I'm rambling. And all right. So Salerno has met, I think, every possible. Anyway, okay, I'm just gonna sign out. Okay, have a nice day. Bye. I got 2 hours before I gotta go to get a procedure done. In the hospital.